Hi, welcome to my channel, Pat Wright Law. I run a small law firm that specializes in patent and trademark work, and love to be able to have a chance to answer any questions you might have. Leave a comment below or a question below, and I'll do my best to get back to you. I'm just going to make a short video today. Just talk about the patent process in general, how it happens, what do you do, what can you expect. Generally, a client will come to me, whether they come to the office or we communicate by telephone or email or a combination of those things. I have clients all over the world, so many of my clients I never see in person. But electronic, the merging world of technology has made it very possible and actually very convenient to work this way. So we take advantage of that. I don't have a big building. We keep the costs down, and hopefully you can appreciate that. But I think we do good work and quality for our clients, quality protection. So anyway, when you come in, you have to disclose whether you come in, as I said, or we talk over the phone. You have to disclose your invention to me completely. The better I understand your invention, the better I'll be able to write a patent for you, or at least tell you whether you should file a patent. Uh, the question I often get is, do I have to make a prototype before I can file a patent? The answer is no, in general, unless somehow it looks like you're violating the laws of physics, then you might be required to build it, test it. But in general, you don't have to have a prototype. It makes it nice if you have one. That makes it an easy way for me to understand it. My background is in mechanical engineering and physics. So most of those type of patents applications I can pretty much see what's going on. Some electronics there, some computer science also. So a pretty good broad education and background. I taught physics for many years in high school and college, and so uh, I'm reasonably conversant in most technologies. So I need to understand it. So however you do that, that's the first step, basically. Uh, then we'll need to obviously arrange fees and things like that. And I generally work myself. This is not standard. Every single practice does not do it the same way, but this is the way that I do it, is I generally will do the drawings necessary for patent drawings. And that's included in my fees. And they're special drawings. They're not engineering drawings. A lot of times my clients will come with CAD drawings and things like that, which is great. It's helpful to help me understand it. But you don't want a patent drawing. It's not the same as an engineering drawing. If you file engineering drawings as patent drawings, it would make it a lot easier to get around infringement, because they're very specific. Patent drawings are more general, trying to capture as much protection as you're legally entitled to. So that's part of the situation. So I would do that generally, and review them, send them back and forth, see if we need to make any changes. Once we agree on the drawings that it represents your invention, I write the rest of the application. If it's provisional, pretty much ready to go. If it's a full utility, the claims, we have to spend a lot of time on the claims, and then we file it. And once we file, if it's provisional, you have 1 year to file a full utility. I have another video, I believe, on what type of patent you should file, and I also have an article on it. If it's provisional, you have 1 year to file full utility. If it's a utility, it will go into the examination queue at the patent office. If it's a provisional, it will not be examined. It's just there to guarantee you timely date in case you need to show when you filed an application. If, just in general, it's taken between, on the low side, very low side, a year, generally 18 months, 2 years is the first time we're going to hear back from the patent office right now. That can change. They've been working on a lot of improvements to get that time delay down. But right now, I would say it's very typical that you're going to be looking at, sometime between a year and a half, 2 years before you hear back. What's the first time you hear from the patent office? Most of the time, I don't know, the percentage, 75, 80% of the time, maybe even higher, you're going to have what's called a rejection. It'll be a first office action rejection. You have quite a bit of flexibility. You can amend, you can argue why they're wrong, why you do deserve a patent, why your art is not the same as what's out there, etc. If you can convince them of that, they will then issue, you will respond, and you must respond to it, file a response to their office action. If they agree with you that it is patentable, they will issue a notice of allowance. Many times they don't, they'll issue a final rejection, and then you have a little less flexibility on what you could do. But there is a pilot program that's been pretty successful, and that you can amend after a final rejection. But in general, you're going to wind up, if you really want to continue, if you've got a final rejection, you're probably going to file what's called an RCE, a request for continued examination. You can also appeal if you really feel the examiner got it wrong and you are entitled to a patent. That can be an expensive process, so it's not as common as a RCE, request for continued examination. If you do a RCE, which is another filing fee, it's slightly reduced over the first one, but basically the same. If you do that, you get another bite at the apple. You can amend the claims and you can argue why your patent should be allowed. And that can go on for a long time. It's impossible to predict how many times that will happen. And of course, every time you get a rejection, it will add to the cost of the patent if you get a patent. And there's no guarantee you could get a patent. In the end, you could also give up and say no more money. I'm going to go without a patent. So that's the basic process. If you get a notice of allowance, you have 3 months to pay the fee. You can buy some extensions time. You can't go out past 6 months, but then they'll issue the patent generally. So that's the overall process. I want to make this a short video. I'm going to try to make several short videos just to help you understand the process. It can be quite confusing. We're also here. I don't charge for this kind of an answer to a question, a legal specific question. Of course, we have fees for, but general questions, what do I do? What do I need to do to file a patent? That type of thing. You're certainly welcome to visit our website. You can comment below and I'll answer, or you can email me or send us a fax. Pretty much any way you can communicate to us. We'd be glad to answer your questions. Again, my name is Mark Torche. I am a patent attorney for about 15 years now, and look forward to hearing from you if you have any questions. Thanks.